Inverse indexing is illegal in Texas, but I have a theory, and it seems to have panned out for some time. I have a theory that the Ku Klux Klan and the vestiges of the Ku Klux Klan still have a considerable hold on the legislature and the executive offices of Texas. The thing about the Ku Klux Klan is, for those that understand, the Ku Klux Klan is different than a white nationalist organization or even political entity. Ku Klux Klan is, so far as I understand, at least in Texas history, not as interested in exclusive focus on racial purity as it is moral purity. And my understanding is that at various times, with acquiescence and sorcery, that the Ku Klux Klan has been able to accomplish its ends in Texas and elsewhere by creating a comparable patronage system to the one that operated in Chicago under the boss. You find individuals within the community that have a likeness with different characteristics, and you give them what they need to suppress dissent and actual authentic expression within that community. You let them contain their own, and you'll give that person, or maybe a couple of people that are loyal to that person, some exclusive access or privilege, up to and including every once in a while, especially in the special way Texas does. White slaves. I've suspected for several years somebody wanted me to try to bring a case against white slavery. White slavery is a specific RICO predicate offense in Texas. The Texas Organized Crimes Code actually specifically mentions white slavery. But in the day, white slavery was not about race. White slavery was an understanding that the designation of white implied a different expectation of considerations of what one could expect of a slave. Trafficking, commercial sexual exploitation, forced prostitution. These are other implications. These are other understandings of the context around considerations of white slavery. It doesn't always have to involve sex, by the way. But what makes it so appealing is when it does. The sexualization of the humiliation is really what you're going for, because it is in the engagement in that sex act that those that seek ritual blessings in performance of a false paradigm of purification actually end up deriving the intended objective, right? This is what I've seen over and over again. At another point in time, I tried to describe it under the context of the Lady Ferguson scam. The understanding that a woman's power is basically as an expression of the man, and that once she has been excoriated, she might be tolerated, but only if he first has been rendered unavailable. This is the way it's been going. This is what I've seen. Whether we're talking about the police, whether we're talking about the judges, whether we're talking about the legislator, whether we're talking about the guy who sells insurance. I don't understand it. I don't really know where it came up as a ritual. I don't know when it became normalized. If you actually read the primary source text of Texas history, if you read the original speeches, the original debates, even the original rules of procedure, performed by the founders of the Republic of Texas and then later the state, if you look over their arguments and their battles concerning secession, whether or not to allow themselves to be a state within the United States, responses to slavery, what to do afterward, all the way up through the first 20 years of the 20th century. There's a very, very comprehensive, very, very strong spirit, including a strong spirit of resistance to the Ku Klux Klan. But years down the road, what do we got? How many more laws are we supposed to allow for them to try to masquerade as something somehow legitimate regarding confidentiality? I've literally been remanded to not being able to talk about anything except food, and I'm not even allowed to have fruits and vegetables. What happens next year? Well, I don't know. Maybe what's left of this woman from Houston, who wasn't from Houston, she got trafficked to Houston, but she tried to, present a particular kind of representation of her experience. Go through the court, try to go on the record, salvage something about justice. We don't want charity, we want justice. I see. What did she say? Well, first she had to respond to this judge, magistrate judge, who was the second magistrate judge, who said that her claims were frivolous. And she refused to state a claim, and she refused to establish either federal or diversity jurisdiction, and that her claims were frivolous. And in accordance with the original effort, that any attempt to appeal would be in bad faith. This is the response that she got to her original request. What does this say? Regarding the later effort, addendum to request for impeachment of Texas State Senate. What does this say? See charges concerning Senator John Cornyn, Senator Ted Cruz, and former Secretary of Energy Rick Perry. I see. So now the consideration is not just about the impeachment of the Texas State Senate for its refusal to impeach the then governor, as well as refusal to address matters related to an attempt to allow for legislation that was blatantly unconstitutional to be put before the voters, including legislation that was encroaching upon constitutional mandates to present information that was required, but also to allow for confidentiality regarding contract bidding that otherwise was legally required, and to allow special exception for the Attorney General in order to negotiate individually contracts with the state without having to report anything about those contracts via any public reporting or accountability structures for the people of Texas, I see. Why would she bring these charges up? You mean the ones that talk about the specific instantiation of a kickback scheme? It goes back 2 decades. And how the later ascendance of state actors for the state of Texas to the federal government support the argument that was in that first petition to the Supreme Court of the United States, which was calling a question on, is this something that happened in regards to crime on the level of the state of Texas that got promulgated to the federal government, or is the federal government involved with promulgating the means by which this local kickback scheme is being effectuated? I see. What's the next thing it says? Due to the refusal for years of anyone in an official capacity in the state of Texas to assist Krause, the award of the estate of Krause's grandfather has been impacted by subsequent events. Refusal of those in the public trust in the state of Texas to assist Krause in challenging the illegal detention and instead aiding and abetting a conspiracy to commit fraud and child abuse, as well as other crimes that included refusing to assist Krause with retraction of the mental health diagnosis, impacted the vestiture of benefits and other inheritance, tangible and intangible. Krause is the firstborn grandchild of a military veteran and a member of law enforcement, at the least, right? What does this say? See surety documents from the United States Army concerning nuclear surety and chemical surety, as well as information concerning document dated for April 4th, 1994, regarding legislation that identifies elements of the pattern as a basis for implications of charges concerning defrauding the estate of Chalmers Andre Lovejoy. I see. So the argument was that elements connected to her grandfather's estate based upon his human capital from what he did while he was alive, which included more than just service in the United States military during the Korean War and a relationship with the Washington, D.C. Police Department, right? There were other things he had as part of his human capital that she understood, would have been able to provide coverage on the anniversary of a report that had been provided by the Congressional Research Service and that was in accordance with a request for consideration of legislation regarding safe handling of chemical, biological, and nuclear weapons within the United States. And that the day he was murdered, in conjunction with her detention and the refusal to allow for her to attend the hearing to appeal the order for the detention, was 2 years before the 25th anniversary on that specific security. And that her concern was that what they had done is murdered him and then attempted to render her incapable of vesting her inheritance so that when the appropriate time frame came, they could sabotage those security elements with which he was associated and then be themselves beneficiaries of the inheritance. Now, in the state of Texas, abandonment takes 3 years. But after 2 years, it would have been the 25th anniversary. A year and a day after the 25th anniversary would have been 3 years and a day after his murder. What happened on April 5th of 2020? Well, by April 5th of 2020, we were already into the COVID-19 pandemic. She has this crazy theory that if people like her grandfather had not been murdered when they had been, and that their murders had not been allowed to occur without any redress or consideration, then there would have been substantially fewer moments of sabotage that would have allowed for the accrual of the financing that is now underpinning COVID-19 and its proliferation. Now, these were not the charges at the time, but things change. What else changed? So, these changes and the implications of their implementation during a declared state of emergency were done in manners that aided and abetted the murders of numerous Texas citizens, including members of law enforcement. Now, this was in September of 2017. We're in May of 2021. What's this note here? Justice Antonin Scalia presided over a jurisdiction that included the state of Texas. Yes, because now her theory is that there was some sort of long-term deal connected to a case Scalia authored. After he authored the opinion in Maryland versus King, her original contention was that Scalia was murdered in part because his dissenting opinion in Maryland versus King could have provided a foundation for a refutation of various precedents, including alleged laws that had gone into effect afterward, including those that allowed for a particular kind of access to people's genetic materials that could be disabused, including in the processes of biological weapons development. But at the time, the major consideration had to do with genetic engineering, including genetic engineering connected to prematurely or otherwise disabling people physically in order to compel them to seek medical treatment, including medical treatment that could be used to entice or extort them into agreeing to cooperate with organized crime. You see, but since this discovery of matters related to the 10-year difference between General Dynamics versus the United States and Chicago versus Fulton, then it becomes even more concerning that the death of Antonin Scalia, which she understands to have been premeditated murder, has gone unacknowledged as a murder, and that it's also in consideration of a pattern or a string of other murders, including against people who had enough political capital to alter the trajectory we're on now. And that these strings of political murders not only have created a chilling effect that prevents the emergence of, or at least the acknowledgement of the emergence of alternative leadership to the status quo at this time, but that is itself evidentiary of what was going on immediately before, during, and since the September 11th terrorist attacks, including its connection specifically with the state of Texas, including its connection with laws that were blatantly unconstitutional but were allowed to be passed through the legislature of Texas and engaged as if they did have constitutional validity. How long can you masquerade that a law or executive action under the cover of the legislature's acquiescence? How long can you engage in such actions in complete abrogation of the Constitution before there's no longer a legitimate or just cause claim to challenge your authority? Has there ever been a case about that? Is there a statute of limitations on such a thing? I don't know. Okay. Leveraging the safety of the people of Texas in manners that are fraudulent as part of a long-term effort to divest the people of Texas of their constitutional rights is not only a violation of the Texas Constitution, but an act of war against the people of Texas. And what did she say? This was her original claim. In January 2020, what is she saying as of yesterday? Invocation of the War Powers Act as a result of COVID-19 is an indication of the definition of levying a war against the people of Texas. Insofar as charges are being filed in regards to Corning, Cruz, and Perry, then considerations to be regarded concerning their roles on the federal level as predicated on their complicity via their previous state roles. I think she had also said something about how at least 3 times since the onset of COVID-19 that a very significant matter in terms of actions regarding sureties for the state of Texas had occurred under the behest of the governor, which substantiated her charges, she believed, concerning the governor willingly and knowingly engaging in frauds against the surety of first responders who are elected to public office in Texas, i.e. SB 4. And what happened prior to the passage of SB 4 when Governor Greg Abbott threatened retaliation against Sheriff Sally Hernandez for supporting the sanctuary cities policy in the state of Texas, despite the governor's rejection or disinterest or disaffection with that policy, and had threatened to cut off state assistance to her district if she did not relinquish her stance in support of sanctuary cities. Our contention was that because the governor is the holder on sureties for Texas sheriffs, that what he did was an act of extortion, and that the legislature and no other body in the state of Texas ended up supporting a challenge to that act of extortion, which implied that there was a possibility that were he to attempt to do that later on and engage it at another level, then there would be no support in trying to protest against it then. Our contention is that since the onset of COVID-19, there have been at least 3 different instances where the governor of Texas has acted outside of his constitutional authority in terms of trying to put under his direct power or authority federal resources, including in manners that allow for them to be recharacterized through bonding or issuance of bonded securities that are actually undermining to the federal government and are in violation of the Constitution. I see. What were those 3 instances? I can't remember all 3. She told me. What did she say? Oh yes, having to do with telling federal agents to turn their bond over to the governor. That happened early on. And then there was the whole situation with the Austin Police Department. Those are 2. Anything else? Oh, we're still going. Instead, the Texas legislature, with the approval of the Texas governor, implemented legislative changes to increase access by third-party contractors to the property of the people of Texas and Texas citizens, and also implemented methods by which to further prevent the people of Texas citizens from exercising their constitutional rights to due process. In pursuit of this exercise of the rights to due process, Krause twice requested via the Supreme Court of Texas a secure manner in which to submit evidence, and was denied both times. And then this brings up matters regarding consider charges concerning the Governor's Commission in regards to current events, as well as the role of the Army Futures Command report and changes to Department of Defense contract awards since onset of COVID-19. I see. So the question becomes one of what role does Greg Abbott have in the gubernatorial commission concerning biomedicine, biotechnology, nanotechnology, and bioengineering that was started under Governor Perry. And not only that, But the concerns that the Army Futures Command has 3 bases in Texas, including its headquarters in Austin, but also including an operation responsible for military medical care that she is concerned is in direct competition, if not outright sabotage, against MedCom in San Antonio. How would those be connected to COVID-19? Well, did anybody ever address the concerns regarding that incident in San Antonio before Hurricane Harvey? I see. No, but there have been a number of small businesses, including small businesses connected to food access, that have been able to secure Department of Defense contracts since the onset of COVID-19. So, there is an accusation of a constitutional breach when it comes to allowing her to submit evidence based upon her religious beliefs. That there is some sort of religious persecution against her that will not allow for her to submit evidence or be provided with evidence. Section 5, witnesses not disqualified by religious beliefs. Oaths and affirmations. No person shall be disqualified to give evidence in any of the courts of the state on account of his religious opinions, or for the want of any religious belief. That's specific. That's in the Bill of Rights. So even at the beginning, when the Constitution of Texas was being first laid out, they made a specific notice to let the people know nobody could say that you were not entitled to evidence to support your cause or to provide evidence of accusations of injustice based upon anybody's unconstitutional religious test. They take that very seriously in the Texas Constitution. You're not allowed to persecute people based on their religion. They really meant it. What happened? Consider as evidence the elements of the Comptroller Code concerning Northern Ireland and Israel as a consideration regarding on account of his religious opinions, as well as concerns regarding motions submitted in regards to 17-0622. Yes, this goes to her concerns that what was happening is that the state of Texas during 2017, in addition to what was going on with the sanctuary cities retaliation, was identifying people that they did not believe appropriately demonstrated their concept of support for Israel as somehow being outside of the protections of the Constitution and rendered available for persecution. This was part of what the alleged anti-BDS legislation, at least for the state of Texas, was. That the specific manners in which it referenced the permanent school fund in the form of school bonds, as well as the pension system, and the specific manner in which certain insurance schemes that are penultimate in consideration of the Texas retirement system and what is offered as part of consideration of end-of-life benefits for people in the state of Texas require a specific perspective on Israel that does not necessarily comport with what would be represented by Israel or those within the territories Israel identifies as its own or subject to. This is the concern. Evidence that the acting representatives of the government of Texas intended to defraud Krause of her personal private property, that made it available for illegal redistribution to others with whom they had engaged via contract in violation of their duty to uphold the Bill of Rights. What does she say? See information on request to Texas Insurance Commission regarding documentation concerning the alleged medical treatment at neuropsychiatric center at Bentalb Hospital. Yes, it's true. The Texas Insurance Code does say that anybody has a right to petition the Texas Insurance Commission to provide certification and verification that the state of Texas authorized any distribution of funds in connection with insurance coverage for any reason, and that they have to provide it within a certain number of days, i.e., if, in fact, there was provision of insurance for those 10 days of medical treatment, then there would have had to have been confirmation and verification with and through the Texas Insurance Commission that it was authorized, and by law, they are required to provide it to her. Everybody in the state of Texas who has ever received medical treatment that was allowed to be billed to any public health insurance provider, or even involving public resources, up to and including through the criminal justice system, that had to get any sort of insurance in order to be provided with medical treatment, is entitled through the Texas Insurance Commission to receive documentation of its authorization and verification, as well as the payments in consideration of those insurance billings. And if they do not respond within a very specific period of time, by virtue of them having the special process they do as the Texas Insurance Commission, they are in default on their sureties. Who holds the sureties for the Texas Insurance Commission? Somebody's going to have to find that out very quickly. I see. So what would have been her remedy in consideration of what happened? Well, there was a PowerPoint presentation she created with 24 slides going through very detailed information on all the laws that were applicable in the state of Texas to anybody who had been diagnosed as having a need for any sort of mental health care or treatment. She addressed it to the legal community, as if to say, if you're a lawyer, this is the least you need to do when it comes to understanding you might have clients that would have need of mental health treatment. And that was in June of 2019. Where is it now? What did the state of Texas do instead when it came to claims of false billings for mental health treatment? Does anybody remember what happened at the beginning of 2019? How many futures agreements did they hook up through an automated process that they've intended to implement since? Do not forget, it was only very recently that mental health services were removed from primacy under the Department of Corrections, isn't it? Now, here at the end, that was the last thing she says. Cross further contends that per their agreed participation in unconstitutional acts with which they then attempted to entice the people of Texas into cooperation via approval on referenda concerning constitutional amendments, that the members of the Texas legislative, executive, and judicial branches have agreed to waive their sovereign immunity. I know. There's since been some concern about this concept of waiving sovereign immunity. Rather, that one does not even qualify for consideration as being under sovereign immunity when they are explicitly abusing their offices in order to advantage themselves personally, and especially if they're engaged in some organized criminal activity or outright seditious activities. But what did she say instead? She went looking for a case. Yes, a case was part of her theory. And at the Southwestern District of the Federal District Court System had a very, very noticeable trend in the last 35 to 40 years of litigation. That there seemed to be almost a dual standard. One for names that had Spanish backgrounds and one for names that did not. Almost as if there was an intentional process. And that for about a decade, certain Spanish surnames seemed to have a particular kind of judicial capital associated with the kinds of cases with which those names were associated. But then over the course of the next decade, it was as if they got inverted. And then by the time you get to the third decade, which is the one we're in now, well, it is as if there is some sort of melding. And in that melding, there's a transposition. There's a specific case she was looking for, which she understood came in the late 90s, early 2000s, around the time that one of these turns was happening. It was concerning members of a sheriff's department in Texas. The specifics had to do with consideration of being qualified for governmental immunity based upon performance of one's ministerial duties. And it specifically outlined a process of consideration of what constituted a ministerial duty, and specifically outlined the distinctions in terms of the roles that sheriffs played over others that are elected to office or other law enforcement. Specifically, that sheriffs do not have the power to decide the judgment, but it is their direct duty to decide how to apply the judgment. So if the law says that your district is beholden to a particular covenant or a particular obligation, you do not get to decide to abrogate that judgment. What you do get to do is decide in what manner to apply it. This can bring up a variety of concerns, but the problem is the actual paper records, the actual books are no longer available to her because she is not allowed access to the libraries. What is available online instead? A case from May of this year, right here in Dallas, concerning another sheriff, not named Gonzalez. Different race, different ethnicity. And this time, it has to do with considerations of application of immunity in regards to the sanitary conditions at a holding facility for people who have been arrested. Very, very different than the original case of concern when it comes to discussions of exercise of discretion in performance of one's ministerial duties. And exactly what she was afraid was going to happen. That they were just going to sit on the case long enough to flip the demographic and to invert the implications of the crime. And then by the time it came to her, she would have already been hung. And so would everybody else whose ass was on the fucking line. And that's exactly what they fucking did. Claim was not frivolous or malicious. Claim states a claim on which relief may be granted. Claim does not seek monetary relief against the defendant who is immune from such relief. We're not even done yet. We're nowhere near done.